Today we have, without a doubt, one of the creepiest human beings I have ever seen in court. He doesn't particularly want to participate, and the first day he cuts it short pretty quickly. But he comes back the second day, and then we'll find out what happens.
This is about this. Don't close. This is about a bond hearing.
Mr. Page?
This is about a bond hearing.
This is an arraignment for a stalking charge.
Is it a bond to this hearing?
One more time, I didn't hear you.
Is there a bond to this hearing?
We'll determine bond as after the arraignment, as part of the arraignment.
You're determining bond? Is it a
Right.
PR notice?
We'll get to that in a minute. We'll have to get through a few other things first.
Like what, sir?
I have to read the charge to you, and advise you your rights, go through all kinds of things, and then the people get to argue your bond. So your public defender is going to talk to you about the case as well. So the first things first, I know you've not had an opportunity to talk to the public defender. Did you want to speak with the public defender before we start the arraignment?
Yeah.
Okay, we're going to put you in what's called a breakout room with the public defender. You can speak with them privately in that space, okay?
Yeah.
Let me just get it set up here. Hang on a second.
You know it's X book, right? You know that's a book of X's, right? I say you realize it's a book of X's, right? X books. You know how you read the books and put the X?
So, Mr. Page, on the screen there should be an invitation to a breakout room. You see that?
Go ahead, you push it.
Yes, I believe he does not want me to represent him in the arraignment. I'm not sure if he wants to move forward representing himself or how he wants to proceed.
Okay, I'll try to get him back here and we'll see what happens. All right, so what's Mr. Page's wish at this point?
There you go. I'm assuming it's over now. Now it is over. All these songs. Take that out. It's over. It's over.
Mr. Page,
Sir.
you hear me okay?
Yeah.
All righty. So the public defender wasn't quite clear on what you're wanting to do here. Did you want to represent yourself at the arraignment or did you want her to represent you?
I want to represent myself in the arraignment.
Okay. You understand proceeding without an attorney, the attorneys that comes at no cost to you, and they do have some expertise in this area, but you want to proceed without that assistance, right?
All I want to do is have this arraignment bond over to a pretrial.
Okay.
That's what you're gonna do, right? Irregardless of what I'm gonna say to you, right?
Let me call the case, okay? Appeal of the State of Michigan versus Christopher Page, Washington County Sheriff Incident 2270715. The allegation of this matter is between the dates of May 13th, 2022, September 1st, 2022. Ypsilanti Township, Washington County, State of Michigan. You did engage in a willful course of conduct involving repeated or continuous harassment of Charlene Virgil. The conduct such that would cause a reasonable person to feel threatened, and said conduct actually causing Charlene Virgil to feel threatened, and at least one of these actions constituted the offense in violation of a restraining order.
Man, get the fuck on, man. You just an arraignment judge, bitch. No, my part, man. That's another fucking lie.
All right, court's gonna take that action to indicate that Mr. Page shouldn't be arraigned this morning. We'll end our hearing today. Thank you, everyone.
So as you can see, the first day went pretty well. I can't imagine why this guy might be considered kind of creepy. Let's see if he wants to take part in day 2.
And I don't know if Mr. Page will be participating with us this morning. We tried to have him have a conversation with his lawyer and that,
we tried talking yesterday too, and it didn't go so well.
Okay.
So we're still waiting for advice of rights on Cummings.
Cummings?
So if you get that signed and sent up, we can see Kunkel in the meantime.
Okay, no.
Or Huckle, or how you say it.
Your Honor?
Yes, sir.
Well, I guess Page would like to participate.
Okay, we'll give it a try.
Okay, give me a second to get down to the unit.
All right, thank you. Yes. Good morning, Mr. Page.
Sir.
That's sup, Your Honor, to you.
I understand you'd like to be arraigned on this charge today?
Yeah.
Okay. Yesterday we gave you the opportunity to speak with the public defender. You declined that. Did you want to speak with the public defender today? You hear me, sir?
Well,
I asked if you wanted the public defender to assist you today.
yeah.
You would?
Yeah.
Okay. Would you like to speak with her in a breakout room like you tried to yesterday? Or just have enough information to proceed without that?
Uh,
Do you want to speak with her in a breakout room like you did yesterday?
yeah.
All right, so now you're starting to see the creepiness. This is kind of the time where he goes full Private Pile from Full Metal Jacket.
Yes?
Yeah.
Okay. Hang on a second. I'll get that set up. All right, Mr. Page, you hear me okay?
Yeah.
All right. Legal State of Michigan versus Christopher Page, Washington County Sheriff 227015. Allegations on between the dates of March 13th and June 1st, 2022. Ypsilanti Township, Washington County, State of Michigan at 738 Wood Creek Court. You did engage in the willful course of conduct involving
There we are.
continuous harassment of a Charlene Virgil. The conduct being such that would cause a reasonable person to feel frightened.
Line, you never breathe.
And said conduct did cause Charlene Virgil to feel frightened, at least one of the occasions constituting a violation of a restraining order. That is a felony carrying a maximum penalty if convicted of up to 5 years in prison, a $10,000 fine, or both. Do you understand that allegation?
Yeah.
Need to advise you of certain rights, sir. You have the right to remain silent because you say on the record can and would be used against you at trial. You have the right to trial by jury, the right to the assistance of an attorney. If you cannot afford an attorney, one will represent you at public expense. Do you understand that?
Yeah.
Or let you stand mute to the charge, entered a not guilty plea on your behalf. People can address bond now.
Lou Danner for the people. Your Honor, in this matter, with the nature of the allegation, Your Honor, we're asking, of course, for the standard no contact order, no going to the listed address of the offense, Your Honor. Also, we would like that the defendant be ordered to be on a GPS tether with a 1 mile exclusion zone of that address and to be fitted with that GPS tether prior to its release. Also, Your Honor, due to the number of contacts, we would request that if in the court does release this individual, that he only be released to an address that is a address in which he's allowed to go to, because right now we don't know where he would be residing. So
I can reside in a hotel like I played yesterday.
Your Honor, that
Yes, sir.
unless and until he actually has a location in which he can reside, that he not be released, Your Honor, because releasing him to go find a place to reside at a hotel will lead us to the same situation that we've been in.
Excuse me, y'all. Excuse me, Mr. That's your word? Is that your last word?
Mr. Page, one person at a time gets to speak.
Believe that.
So, Your Honor, we would just request that, one, that there be a verifiable address that he be released to, and that he be fitted with a GPS tether prior to his release with a 1 mile exclusion zone from the listed address.
I can't have a GPS till I'll be going to a hotel. I have
Hold on a
money.
second.
I work,
Mr.
excuse me,
Page,
I-
Mr. Page, hang on a second. Thank you, Mr. Danner. Ms. Perny?
Yes, Assistant Public Defender Lauren Perny on behalf of Mr. Page. Mr. Page would like to request a personal bond. He is seeing a judge on the PPO violation, which is scheduled for the 8th. So he will be in custody until then. Magistrate Fink denied bond on that. We did not get to where he is staying, so I don't have any further information on that. I know he previously was working with CMH, so I can refer him to our social workers so they can see if CMH or some other resources can help him find some more stable housing. And obviously he's indicating
Why
that
are
he
you
can't get
sending
out.
me back to CMH? So you just gonna be in the same cahoots. What I'm trying to tell you is this. I came to jail this time and I was released from CMH. All I have in CMH is a PPO. I have a job working construction and I paint. I make that like $14,000 a month. I make $1,000 every 5 days. I'm sorry, I make $1,000 every 2 days. And I stay in hotels. All I gotta do is go home and get my job back.
Okay. Preliminary exam, September 27th.
Well, I know I ain't getting in this case. So this is the last case of the home team.
All right, sir, let me get your next court dates on the record and we'll go from there. Your next court date will be September 15th at 9 a.m. for probable cause conference. Doesn't resolve at that hearing, proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony. There's probable cause crime is committed, probable cause you did commit the crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter would be bound over, meaning transferred to a circuit court for trial. Do you understand that?
Yeah.
All right, condition of bond is you're not to use or possess alcohol, illegal drugs, or marijuana. You're not to leave the state of Michigan without permission of the court. You're not to have contact with Charlene Virgil. You're not to go to her place of residence or employment. You're to have a GPS tether prior to release to assure compliance with the not to contact, not to go to orders. These conditions will be placed in the law enforcement information network, meaning should you come into contact with the police, they will have access to that information. Should they witness or suspect a bond violation to have occurred, you would be arrested for a bond violation. Do you understand that?
Yes, sir.
Okay. Courts determined that based upon the nature of allegations for protection of the public, in addition to the conditions placed on the record, that a cash bond is necessary for public safety. Bond to assure appearance of court dates and for public safety set in the amount of $25,000 to be posted either in cash or corporate surety, subject to conditions placed here on the record. All right, Mr. Page, you are all set. You have a good day. Stay safe, okay?
Excuse me, sir. What you're saying is if I'm released on the cash bond, I go to tether?
You have to have a tether before you get out of jail if you post your bond, correct?
That's some bullshit, man.
Have a good day.
Y'all better, this is bullshit happening to my daughter. I'll show you here.
Oh, you poor little man having to be released on a tether. Maybe it's something to do with the fact that when that young lady opens her curtains, this is what she sees.
Yes?
Yeah.
So yeah, it's probably very necessary. But because you make $15,000 million a day, I don't think it's going to be too much of a problem for you. Well, anyway, folks, thank you so much for joining me. I really hope you enjoyed this extremely creepy video. If you did, make sure and hit that like button, comment, subscribe. Consider becoming a channel member or a Patreon, or hitting that thanks button down below. We'll catch you in the next one. Sláinte.